Hi, I'm Katie, and this is my partner Linda, and this is Proposition 22. You'll see it on the ballot as exempts app-based transportation and delivery companies from providing employee benefits to certain drivers. So Linda, can you tell us the question posed by Prop 22?
Sure. Prop 22's question to voters is, does current law apply to app-based rideshare and delivery companies? And should these companies classify drivers as employees rather than independent contractors?
And what's the current situation for app-based drivers?
California requires employers to comply with a set of labor laws enacted to benefit employees, including minimum wage, overtime, workers' compensation, and unemployment insurance. These laws do not apply to workers classified as independent contractors. In September 2019, California enacted Assembly Bill 5, which limits the type of work independent contractors may be hired to perform. The new law adopts the ABC test.
So what is the ABC test?
The ABC test requires an employer to show that its contractors, A, work independently, B, perform work outside the hiring company's core business, and C, are customarily engaged in an independently established trade, occupation, or business of the same nature.
And this is the current law?
Yes, the California Attorney General has stated that current law applies to app-based rideshare and delivery companies, and therefore, these companies must hire drivers as employees. However, these companies continue to hire drivers as independent contractors. The Attorney General, along with attorneys from major California cities, is suing to force these companies to comply with the law.
So what does Proposition 22 propose?
Prop 22 would allow app-based rideshare and delivery companies to classify drivers as independent contractors under the law, thereby overriding Assembly Bill 5.
And what does that mean for the companies and the employees?
Drivers would not receive employee benefits and protections. Instead, the proposition would require app-based rideshare and delivery companies to offer a new set of benefits for drivers, including minimum compensation levels, healthcare subsidies, auto and injury insurance, and so on. This measure also would prevent local jurisdictions from enacting their own rules for rideshare and delivery companies, such as the establishment of a higher minimum wage.
And what fiscal effect would Prop 22 have?
According to the Legislative Analyst's Office, the measure would yield a minor increase in state income taxes paid by rideshare and delivery service company drivers and investors.
So what do supporters of Prop 22 say?
Prop 22 protects the ability of app-based drivers to choose to work as independent contractors with control over where, when, how long, and for whom they work. Proponents also say that Prop 22 saves hundreds of thousands of jobs at a time when millions are struggling to pay their bills.
And what about opponents?
Opponents say Prop 22 would absolve these companies of the responsibility to contribute to Social Security, Medicare, unemployment insurance, workers' compensation, and other social safety net programs, shifting the burden to the taxpayers instead. They also say Prop 22 would create an unfair advantage for companies that don't follow labor laws, threatening public and private sector union jobs and stripping away control on workers' rights.
So Linda, in summary, what does a yes vote for Prop 22 mean?
A yes vote supports changing labor laws to define app-based rideshare and delivery drivers as independent contractors and adopting policies specific to these workers.
And what does a no vote mean?
A no vote opposes this measure, meaning that AB 5 would be used to classify app-based drivers as either independent contractors or employees.
Thank you, Linda.
My pleasure, Katie.